I think that everyone has come already. So let's start our round table dealing with delegated ownership. My name is Mikhail Gamperin. I will be the moderator of our roundtable discussion. And since many speakers have fallen ill this morning, probably I will also make my brief presentation if you allow me to take the floor. I will give you some brief information.
И говорят,
между прочим,
Чем обусловлен вообще выбор такой темы?
Why have we chosen this theme? At least in the Ministry of Justice, at the Department of Economic Law, they have been studying that theme primarily related with the problem of succession in business, because in the framework of the general work carried out by the government and administration of the president in the sphere of economy, and this task is also formulated in the public formats. It is necessary to create such conditions so that business, small businesses and large businesses and the citizens would use the structures that are offered by the Russian law for structuring their assets. A detailed analysis of the problem was carried out, of the problems related with withdrawal of business to foreign jurisdictions, not as main, but one of the problems was, in the opinion of the experts, the lack of proper instruments for structuring, management and transfer of property, including personal and corporate property in the Russian law. Therefore, there was an idea of discussing the matters related with succession and inheritance of the property in the Russian Federation and inheritance in business. Today, there were we offered different formats for discussing these matters, and we wanted to discuss it on a broader basis. And we're going to discuss the structure of delegated ownership in the law of Russia and in the law of other countries that are used by the Russian business for structuring their assets. So first, I would like to give the floor to Veronika Misutina, because she, at the state level, for the first time, has worded the problem. And I would like to ask her to dwell on the requests of the business which exists currently with respect to the Russian law and the problems which make our compatriots to find the best legal situation abroad. Thank you. Thank you. First of all, I have to tell that I'm really flattered that I can take part in this meeting, because I am not a lawyer, I'm a financial and tax specialist. Since starting with 92, I have been dealing with tax practice for the Russian companies and the owners. I can see the problems that are facing them. Last year, the company PricewaterhouseCoopers conducted global research of family and private businesses, and we, for the first time, involved Russian companies into this study. Unfortunately, I cannot show any slides, but you will receive the materials which present the results of these studies, and you can see that the first generation, and we have to deal with the first generation of the Russian businessmen who seriously think about the succession in business and about the mechanism that should be used so that it is sustainable and reliable, so that family capital would be retained and preserved. Up to now, the most attractive decision for the first time were trusts under the foreign law, to a lesser extent family foreign funds. Why are they so attractive for the owners? They make it possible to divide the legal ownership and management and beneficiary property. Beneficiary property might be fragmented in any way, and these structures offer a possibility and the of having full flexibility when drawing up the documents regulating the activities of the trust and the foundation. What other characteristics of the trusts are attractive for owners in business that they cannot find among the Russian alternatives? This is a possibility of trying to establish a new system during the lifetime of the owner, so the problems of succession are resolved in the process of vital activity and flexibility in respect of testaments under the trust of foundation, the possibility of protecting against creditors and against property risks in case of disputes between the spouses during the divorce. However, there is certain debatable issues mentioned by many customers. In their opinion, organization of the ownership by the Russian business via the foreign structures to a certain extent makes it possible to manage the political risks. I don't quite agree with that, and we probably should discuss that issue. To a certain extent, fashion is quite important because the entrepreneurs communicate between themselves. They tell each other about the difficult structures, and many of them want to follow the example of their big brothers, but having all these wonderful characteristics of the foreign trusts and foundations, our colleagues will make more detailed presentations on their properties and characteristics. However, there is an opposite trend that makes people not use it at all or find some alternatives. Any trust is a foreign trust is a foreign element that is involved with new risks for the country, as was shown by the experience in Cyprus recently, and sometimes it becomes quite costly. In addition, a foreign trust not being a legal entity in most cases involves total refusal from control on behalf of the owner during his lifetime. And psychologically, this is quite difficult, though there are different mechanisms that make it possible to for the main beneficiary to affect the events that are happening in the trust. In addition, there is a serious international and country struggle for disclosure of the information, for exchange of the information between the countries. Probably you have come across with the consequences of the new American rules, FATCO, or automatic mode on information exchange between some countries of the European Union. There are expanding measures on combating tax evasion, which some years ago was regarded as permissible, is currently in the blacklists of fiscal authorities of many countries. Russia is not an exception because there appeared a new judicial practice, and the rules of tax code will change with respect to the rules of determining the beneficiary owner with respect to the revenue paid from Russia. And the Minister of Finance is currently introducing the regulations on controlled foreign corporations and some new legal rules and regulations, as you know, in the sphere of currency payments and the use of foreign accounts, and the rules for the civil servants make it possible to use the foreign structures, if not impossible, but quite difficult and costly. Against this background, I think it is high time to think about making an alternative to the foreign trusts and foundations in Russia in the form of the Russian Family Foundation that will be able to engage in commercial activities, but will allow reaching what cannot be done by other legal entities now, to divide the beneficiary ownership and legal ownership and to fragment the beneficiary property. Being a tax specialist, I can see a very fine decision from the viewpoint of such tax regime for such a family fund under the current law. The general tax code should be applicable to it, including the new benefits and the benefits that are available and the benefits related to selling of shares and dividends and the distribution from the funds to the benefit of beneficiaries will be equalized to dividends. There are some detailed issues so that we would cope with the situation when such foundations are used for tax optimization. And the mechanism is available in the tax code. There are some debatable issues, and I will be glad if we discuss them today as to what extent the foundation should defend the property from the claims of beneficiaries and how to observe the interest of minors, of children in case of property disputes, and of course a delegation of the authority between the managing funds and the beneficiaries, who controls whom and to what extent. And I hope that we're going to have an interesting discussion on those matters. Thank you very much. And I would like to ask the audience to ask questions. So if you want to take part in the discussion, or if you want to ask a question and to make a remark, you are most welcome to do it, and we'll be grateful to you for your comments. Probably after each presentation, we should have a question and answer session so that you won't forget the statements made by the speakers. So if you have any questions to the previous two speakers, you are most welcome. Please raise your hands. Please take the microphone. It is impossible to translate without the mic. Sergei Zapasha, High Arbitration Court. Could you give an example when the Russian legislation doesn't make it possible to solve certain problems as compared to the trust? Can you give the most urgent example in respect of the needs when the people want to do something but cannot do it? Probably the most topical example will be the situation with the transfer of the shares to the heirs. Of course, the shares can be transferred, but how should this be done? During the lifetime of the holder, I mean the succession, during the course of the life. In case of a inheritance, there are some technical issues as well. First, there is a process which, at the time when it is implemented, suspend, so to say, the question of disposal of the shares, and the heirs eventually, after effecting the process, become shareholders. This might not be the purpose of the present owner. He has the right to have the following purpose, so that the heirs would receive only revenue on the shares, or probably his purpose would be. I have answered your question already. My apologies. Since we have a free discussion, I will make a brief comment as to what it is difficult to attain in the Russian law developing that idea with shares. Probably two aspects are difficult. First, the entire mechanism of succession involves a transfer of the property right of the title from to the heirs, and the heirs will receive the entire right of ownership or title after making all the procedures related to the succession and inheritance. Sometimes the owner of the property or beneficiary of the business might be interested in restricting the authority of the heirs on exercising their title to shares or for the rights authorized by the shares until they come of age or become mature and reach the age of 30 or 35 years. So it is possible to restrict the right to dispose of the shares because that is family business important for the beneficiary, and the heirs having a possibility of getting the revenue generated by the business should have no possibility of disposing it or alienating or attracting some other investors or replace themselves with other investors. This is the first technical aspect that has not yet been solved under the Russian law so far. And the second practical difficulty relating with exercising the rights of the shareholders during the period between opening the inheritance and reception of the property due to dynamic situation, and since some questions have been resolved and some authorities delegated at the level of the shareholders, if there is no adequate practice of managing the share before the heirs accept their heritage, there is a risk that the decisions will not be taken or will be taken by the people that do not fully comply with the interests or don't have enough trust of the owner. And if we formulate it technically, this is a technical formulation of the themes that we are discussing. No microphone, it is impossible to translate, I'm sorry. Including St. Petersburg, Terехova Maria Viktorovna. The procedure of inheritance, including inheritance of shares, is fully regulated. We have the procedure of beneficiary managing of the inherited property. I don't know how it happens in other regions, but in this city, quite often we have the beneficiary management of the inherited property. According to our legislation, according to our constitution, there is a right of inheritance. In our civil law, there is a universal succession. There is no singular right succession. A family foundation is a good idea, but since we have a universal succession of the right, that family foundation is a notion borrowed from other systems of law, where singular right succession is possible when a part of the inheritance might be accepted. With us, that is impossible. We have other mechanisms. If there are several heirs and they are not planning to become shareholders and cannot do it, he has a right to conclude a contract on division of the inherited property with other heirs, and it will determine what property will come to a certain heir. And this is just a technical aspect showing how this is regulated. You said that it is regulated after the death.
But it's regulated after death and by the will. And during lifetime, the owner has a right to decide. Actually, the family fund can actually set certain limitations, but the right of ownership is guaranteed, and nobody can limit in any way the rights of the owner. If I want to limit the right of my heirs to anything, I will not be able to do it. But many of the entrepreneurs in the family business say that the family should be protected from wealth, and the wealth should be protected from the family members. And I'm sorry that our Italian colleague is not with us today, because Italy, for 20 years ago, has actually established such a strange entity as Italian Trust within it. It has Italian beneficiaries and founders and trust managers, and these trusts have become very popular mechanisms exactly for the transfer but the rights of the legitimate heirs have not been refuted, and so the system exists everywhere. And trust, no matter how much we want, the interpreters want it to work, will protect the interests of the family and the rights of the family. But any family is a community, and in any community there are problems, and any inheritance case is unique. So no matter how much we try to make sure that an heir or a certain heir does not get a certain share of the estate, we cannot do much about that. We need to understand technically that we have all the provisions necessary for that, and we shouldn't think that we can in any way infringe on the rights of the heirs, depriving them of inheritance. A short comment in response to your rather deep analysis. As for the technical issue, the management of the estate after the opening of the inheritance, of course there are instruments, and there are two aspects here. First of all, it's the appointment of the trustee who is going to carry out this function, the notary most probably. And if the heir does not specify all these details, then how to go about that, and how notary will look for this trustee if the trustee is mentioned in the will, in case the inheritance has already been transferred to a family fund or some sort of a private fund. And another important issue in this context, well, of course, the trustee will be appointed, and the Russian law that does not give clear criteria for the functions of this trustee. Will he be able to approve the transactions or not, and veto them, or join his or her voice to the other voices? So it's impossible to foresee all these details. Later on, I'm going to speak about the standards of the work of the trustees. And in Russia, legally, we have not have been able to detailize this. Now, that's an interesting discussion, and there are different viewpoints, of course. Then we were getting ready for this roundtable discussion, and during the preliminary work carried out by us, we could see that the issue of trusts very often leads to a certain manifestation of elegy. And there are two viewpoints. Some say that trusts are very much needed, and trusts should be similar to the ones we can find in the English and American law, and there is a different viewpoint, which our colleague described already. We have everything regulated. There is the constitution, the absolute right of ownership, and we have structures, inheritance that have been tested over decades, and the rest of the questions are associated with the lack of understanding of the advantages of these structures. So the business, for that reason, just the wealthy citizens moved to foreign jurisdictions to build their estate there. Now, here I would like to mention the following for the sake of the discussion. It's obvious that for the ministry and for the body responsible for the policy in this sphere, well, of course, business objectively requires that. We can't say objectively that everything is properly regulated within the Russian legal system. And this is manifested not only through publications, but actually this is manifested through the flight of capital from Russia. And it's difficult to do just with a legal education of the welfare citizens about the opportunities and possibilities open for them by the Russian legislation. And I suggest that today we discuss what needs to be done and what can be borrowed and what positive aspects we have, and mention the ones that we're missing. There can be two planes of discussion, so to speak, and one is to look carefully at our legislation in order to understand the problematic spheres. First of all, in the field of the law on inheritance, in the field of corporate law, in the part of it that is associated with the shares, with the inheritance and succession. And the colleagues have already said that there is a problem with the appointment of the trustee, and actually there is no profession of trustees yet, and hence there is a lack of trust and confidence. And the issue of the management of shares, the transition period from the time the inheritance is open and up to the moment when the ownership title is properly documented. Well, it's exactly over this period of time that there is a danger of raider actions and other illegal actions, and that's what the heirs are very often afraid of. And of course the flexibility issue is important, the possibility of dispose of one's estate, and actually to make sure that the will is going to be followed. So hence this idea of a fund, a family fund, you can call it whatever, but it's an economic title indeed. The lawyers might think of a different name for this type of a fund or foundation. It can be not a corporate structure, but a structure based on contracts and agreements. Anyway, there must be a special mode of control and management, and a person can transfer his or her estate to this fund and give instructions to the manager concerning the management of the fund, whom to pay after the death and whom not to pay, what other conditions are to be observed, marriage, other conditions and preconditions. Anyway, it's the right to manage one's own property. And although, well, of course, there are certain traditional structures that do exist in this field, the ownership in other jurisdictions have all these opportunities. And since all this is very much needed, the owners very often move to other jurisdictions, and then this point changes that are required, that are to be defined. The other alternative is more radical, and it's associated with the creation of a special regulatory system in the field of inheritance law. And inheritance law for us is, well, actually leads to a more general problem on delegated ownership. And look at the possibility of creating a structure or specialized regulatory system for that purpose. Well, of course, we all understand that this is a rather difficult issue, and today we might expect certain interesting ideas. Anyway, we can try to understand where to go and how Russian and whether Russian legislation really misses these mechanisms or not, and maybe the radical changes are very much needed, but we can talk about that. So I proceed from that. We cannot just say that everything here is just perfect and there is even no need to discuss this issue. I think we should discuss it, and that's why we're here, and we should look at this particular issue at a different angle, wider angle indeed. You wanted to say something? Please, microphone. The microphone is not being used. Sergei Lukashov, St. Petersburg. Well, I'll repeat my comment. I disagree with the previous speaker. I don't think that everything is properly regulated in the Russian legislation concerning inheritance, and the trust system really infringes the rights of the owners. The owner can dispose and accommodate the property. We're not saying that there is an alienation process. We're actually saying that there is an alienation. If we take the trust law in Great Britain, for example, that is the expression of one's will, and actually that is alienation. And then as for the management of the estate, that's a different story. And another important issue for today, and that's what I would like to speak about. There are plans of establishing family funds in the Russian Federation. That's an alternative for the it does not replace the system of management in the inheritance law, but it's just a supplement. And a very difficult issue in view of the trust legislation is the structure of the estate that is transferred to trust. If we take business and stock, and if we take into consideration the dynamics of the business and the wish to carry out restructuring of this business, then the trust system makes it more difficult, because the person actually transfers the property into the hands of the trust and cannot play such a significant role any longer. Good morning, everybody. You're Olga Yushko, Novosibirsk. I do believe also that we lack this institute, and there is a great need to have it. I wonder, when the funds, the trusts are being discussed, some of the authorities speak about the new Stiftung. So we wonder if there is an attempt to understand the level of responsibility and liability of these managers, because abroad usually lawyers are involved in that, and businessmen do understand that they have a lot of experience in that. They manage funds and trusts, and their fathers and grandfathers had been doing that. And we wonder if there is any new level of liability for these managers. Will there be any form of insurance? And maybe there will be other approaches, the approaches based on the self-regulatory norms, and what is going to be done about that. Allow me to try to answer your question. Among speakers, we were saying exactly that, and that is why one of the presentations I'm planning to make in a couple of minutes will be dedicated to the standards of work of the managers and their responsibility and liability levels. So in a few minutes I'll do it. If there are no more questions, I can start doing it now. Or if there are questions, we'll answer them. So we'll raise this issue of standards, what the manager should do, and how he should use both carrot and stick in his work. Other questions? Are there any general questions concerning the general issue of trusts, whether we need them or not? And if you have them, do ask them. And then Mikhail will speak about the fiduciary responsibility of the managers. I would like to add, well, of course, this profession will be new, and there is a need to have it. And I was invited to the Skolkovo Business School to develop a new course for the managers of the trust funds. For the family funds. And, well, of course, there must be new regulatory norms as well, whether they are on the basis of self-government or on the public level. No, for some of the speakers here, it is not going to be a surprise to hear what I'm going to say. But I ask the question because it concerns the general aspects of this problem, the basic aspects of this problem and the discussion. I will disagree with those who believe that Russian law is good enough to regulate all the relations and to settle all the issues mentioned by our colleagues. I don't like trusteeship that actually is not associated with the proper level of liability for the estate. I disagree with some other ideas and the absolutization of the right of ownership. But I think there is this implementation of the institute is an illusion. Well, I would rather put it in the following way. We wonder if we can correct anything in the point-like way without introducing a new institute that is going to be extremely alien to us. And all of you who work in this field, you know that for centuries and centuries, Lord Chancellor was responsible for the king on the basis of common law. There was always a conflict of interest. There was fiduciary actions in favor of other individuals. For Russia, it's a very difficult task indeed, and it expresses in different problems wherever we come across this issue, in all the agents' relations, in all the types of agents' relations. And it seems strange to me that we are discussing inheritance and succession, because in Russia there's a great illusion that there are no trusts in the continental system. There are fideicommissation system, an old system, ancient system indeed. No, нет, вы не обогнали переводчиков. That makes it possible to resolve many of the issues that are being discussed today. Allow me to be a commissioner in this case and a legal entity, and probably this is sufficient to settle the problem of the family funds. Dear colleagues, the issue is as follows. We wonder if these point amendments are correct and sufficient. Delegated ownership, trust, probably there is no need to introduce the trust system into the legal system. Probably we can deal with more with finer approaches in compliance with our tradition. Indeed, it's a question, and the answer to this question is not obvious even for me.
Thank you very much. May I make an organizational point for the start? I would kindly ask you not to change so quickly the microphone in order to give the interpreters enough time to reflect the discussion. They do a marvelous job, but it is a difficult job. May I take the opportunity to talk to you about the Swiss experience? I'm from Switzerland, and I can assure you this problem is not resolvable. And you cannot take it up in doing new legislation. What you could do is to ascertain that foreign trusts are recognized in Russia. But then, in the second stage, when it is the question, what are the effects of this foreign trust in Russia, you have to see whether it fits with your rules or not, with respect to the tax rules, with respect to succession rules, and so on and so forth. I think this is the only way how a civil law country can fit with this problem. The Italian solution, ladies and gentlemen, is not a solution. Italy just said, we have trusts, but they didn't do anything after it. And so you are in an empty mess, and you have no solution. Whereas if your tax authorities have internal rules how to deal with this split ownership, there's not a problem anymore. But don't try to copy the Anglo-Saxon system. This is not possible. Thank you.
Спасибо большое. Спасибо большое.
Thank you very much. I think we have, so to say, the second fork. What is better, to recognize the thing that some other countries have, or to create something new in our country? If we recognize the procedures that are available in other countries, for instance, if we levy some taxes and people will set up their trusts abroad and the state will be just collecting money, the idea is not is more extensive. The idea is not just to counteract tax evasion. The idea is more general, to consider matters, and this problem is very complicated. And in Russia, we have been trying to solve it for 20 years. And we have to understand whether we can act in such a way that the Russian law, which is rather flexible, at least it has been flexible quite lately, which is shown by the discussions started around the civil code and trashes that was signed by the president and approved by the State Duma, and the future ones. The Russian law currently perceives a lot of structures and takes them into account, and sometimes successfully, sometimes not successfully, it tries to develop the structures that would reach the same purposes as the structures that are needed in commercial practice and in private law, the structures of the common law. Thank you very much for your remark. I don't know whether we'll become more pessimistic or more optimistic as a result. Then probably I will give the floor to Mikhail Makhotin, who represents the British and American legal order, because our British and American speakers have fallen ill, probably awaiting a lot of questions and attacks, and Mikhail will give general information about the regulation in the British and American system, and he will concentrate on fiduciary owners. And after Mikhail and after the discussion, Peter will present the German experience that has been always most important and interesting for Russia. Please, Mikhail. Thank you very much. Before I discuss the technical theme, because this is a professional legal meeting, and an attempt was made to analyze some finite legal issues, and now I will concentrate on general statements to protect the working group and the discussions which have already taken place concerning incorporation of trusts in Russia. No one speaks about split or shared property or introduction of fiduciary property in Russia. Presumably, in the course of the working discussion, will create another form of legal entity, non-commercial organization such as a fund. Funds exist now and they own their property, and a similar fund will be set up that will own its property. The question is that now, in charitable and other funds, the authority of the fund is that of ownership, but the statute of the fund formulates certain tasks and challenges for the bodies of the fund, and they have functions similar to that of the charitable trust. They exercise the authority of the owner and they fulfill the will of the founder that is determined by the statutes. Relating the situation to the situation of a private family fund, the founder similarly forms the property of the fund. He becomes its owner, and the will of the founder determines the procedure of managing that property. So trusts in the classical form in the Russian law probably cannot exist, but the question is that there is a need and there is a public attitude which require regulation, and At present, as shown by practice, the Russian entrepreneur probably cannot find adequately regulated relations in Russia or duly regulated relations. Hence, if you analyze it not from the legal but from the business viewpoint, from the viewpoint of requests and the tasks that are formulated to the law enforcement bodies by business, we might distinguish the following items as is shown in the slide. Undoubtedly, this is an attempt to separate some personal property or business assets from other business property from the claims of the creditors. These are issues of strategic planning, solving the problems of inheritance, continuity of managing after before the heirs accept the property. Probably some tax efficiency will be attained, and undoubtedly the determination of the person who will manage business assets and personal property, a professional manager. Another issue that is probably not always in the foreground on our agenda, but still it is one of the most critical issues, that is insurance of efficient management of such assets. When a certain instrument or trust is created abroad, it is presumed that the trust manager or trust owner or fiduciary owner of the property will efficiently manage it. On the one hand, this is the information that is transferred from one businessman to another, and there is a certain belief that the management will be efficient. Are there any legal instruments that will ensure the efficiency of management of the trust that is other that are insured in foreign jurisdictions? Are they available in Russia? Thus, in the next slide, you can see our vision of the principally possible mechanism of ensuring the efficient management. And my presentation will be focusing on the efficiency of management and standards of the action of the manager. The mechanism can be classified under legal and non-legal. Non-legal mechanism mean reputation, experience, personal relations with the founders. As to the legal mechanism, they can be subdivided under private law and public law. Public law mechanism can be discussed. We didn't focus on that. These are self-regulated organizations, standards, potential licensing, mandatory insurance, determination of qualification requirements, and so on. But it is also quite important to take into account private legal mechanism ensuring standards of activity of the manager that make him to manage efficiently, and protecting the founder and granting to this founder of the private fund or trust the necessary comfort. And thus, among such mechanisms of private legal mechanism, one distinguishes the distribution of authority and decision-making on how the property will be managed, and sharing of the competence and authority, and which is even more important, determination of certain standards of behavior in the legislation and the judicial practice, the standards of activity of the fiduciary manager, and the responsibility for infringement of such standards. Thus, in the international practice, there is a concept of the so-called fiduciary duties that permeates in the common law system a great number of institutions related with the situation when the manager doesn't manage his property, and formally he has certain authorities of an owner to a certain extent in respect of management. So he should exercise the management duly. What is due management? And conditionally, that fiduciary duty on due management can be divided under three basic elements. The first element, which in the British version is called duty of obedience, it involved following the limitations that are worded in the document by the manager, and the mechanisms protecting the founders or owners or beneficiary of the trust of fund against misuse or violations on behalf of the manager, but in the Russian legislation, such instruments of sharing the competence are available between the authorities, the bodies, and the founders, and they're often met. And the second two duties are not present in the judicial practice of Russian legislation. That is the so-called duty of care and duty of loyalty. So the duty of showing due care and the duty of acting only in the interest of the beneficiary of the managed property. If we analyze the Russian law, probably the first question will be what norms should be taken into account, in what situations in the Russian legislation there will be management of someone else's property in the interests of other persons. It is quite simple. This is a situation when one person has an authority of an owner and the second person receives benefit. So the person exercises the authority of the owner not in his interest. Such situations are quite frequent. They are shown in the slide, and of course starting with the simpler situation of fiduciary activities, standards of action of fiduciary manager, all three types of agency contracts. It is the obvious part, but also it should be noted that the managing bodies of commercial organizations and non-commercial organizations essentially also exercise the authority of the owner property that belongs to commercial and non-commercial organizations, but that is done in the interest of the organizations or shareholders. But there is a situation of splitting in any case. And the most important aspect of private funds is that, in fact, if we speak about non-commercial organizations, the standards of activity of the persons that replace the bodies in non-commercial organizations are even more complicated. On the one hand, they have to ensure the efficient management of property and attaining certain technical tasks. On the other hand, eventually non-commercial organizations and funds have to ensure the attainment of statutory purposes and of those tasks that were initially inherent. So essentially we have the task at minimum to preserve the property that constitutes the basic assets of a non-commercial organization on the one hand. On the other hand, we have to reach the purposes that were formulated by the founder. As we see, the situation in the Russian law is quite versatile, and sometimes it would be quite handy to speak about fiduciary duties in the British and American law. In the Russian law, as we commonly discuss the duties of care and loyalty, in the interests of the beneficiary of the managed property, and there is no proper delegation of authority to the full extent. So I have outlined these three constituents, but these are just beautiful words. Duty of care. Let us write everywhere, and that our law and civil code provides for that our organs should act worthy. And as to the fiduciary manager, it is said that he is not responsible if he doesn't show duty care. Should we add it to the agency contract for a non-commercial organization that is done through the rules? The authority should act in the interest of the legal entity conscientiously and reasonably, and the question is not solved because the requirement of duty care isn't reduced to the indication of the duty of care. It is subdivided into two elements, and these elements can be divided into active and passive. On the one hand, when exercising certain activity, the manager should act rationally. On the other hand, if the manager has an irrational or unreasonable action, in this case, he might be made responsible, and the transaction might be contested if the other party didn't know that it is rational. On the other hand, when exercising the activity, it is important to give to the manager the possibility of taking an independent decision and to take certain risks so that the management is efficient, and the requirements on the reasonability of taking decisions and responsibility for any losses or reduction of the property as a result of rational actions of the manager, which later appeared to be not well thought, not due to inadequate work, but due to the fact that he couldn't foresee the future, which unfortunately is not often possible. And as to the punishing, that would result in excessive passivity, and he will not have an incentive to manage efficiently. When taking reasonable decisions, if irrational decisions are taken that do not lead to increase of the property, that is not a ground for responsibility. The ground for the responsibility is only an irrational decision that has no reasonable foundation. As to the requirement of duty care, which is most important, it is not represented in the Russian judicial practice or legislation that is requirement on taking actions. We are not trying to assess whether the management was correct or not when a certain transaction was made. When we speak about the fiduciary manager or legal entity, we very rarely assess the properties, the possibilities which he lost without managing the property, and the possibilities that are potentially present. It is also important the exercising of activity on control over the property and imposing on the manager of the responsibility for the actions of the third parties that are related or not related by contractual agreements that are aimed at reducing the managed property. So delegation to the manager the burden of active monitoring of situation with the managed property and the responsibility for the fact that he is too passive and is not doing anything, that he doesn't exercise control, doesn't allow dilution of the property, but due to his passivity, non-participation in the affairs, in the management, this results in the loss of economic value or physical loss of a part of the property due to theft. And for certain types of management, the fact that in the Russian law, either in the fiduciary management or agency relations or provisions of non-commercial or commercial organization, it is not provided that there are any cases when there is a duty of the managers to take certain actions. For instance, in the British and American law for trust managers, there is a certain standard at the legislation level that has been approved on management of the investment assets or business assets. They have no right just to sit within the money or to invest everything to one type of securities. There is a legally valid standard of activity. That is not a requirement to invest into certain securities. It is necessary to diversify the portfolio, to manage the risks, and to follow the generally available information in the market. Hence, this is a more specific duty of acting. It cannot be assigned to the general part of fiduciary duties and duty of care, but for certain types of relations on management, actually this exists and is in demand. Thus, the first part of the duties is duty of care, and the second part is distribution of authority and competence. We are not going to dwell on it because in the Russian law, the distribution of competence between the bodies is discussed in detail. The distribution of the competence between the manager, fiduciary management, and the third constituent is the requirement to act in the interest of the beneficiary. There is no word exclusive, but the requirement to use exclusively in the interests of the beneficiary, and hence there are certain elements of duties of the manager to act exclusively in the interest of the beneficiary, not in his own interest. And thus the first most frequent example that is regulated in Russia, which we're going to discuss later, is making transactions by the manager in which he is personally interested. A simple example, when a manager is another party to the transaction, or another party of the transaction is an affiliated company. In different countries, in different situations, the standards, legislative standards and requirements to the manager might vary. In certain cases,
in classical Anglo-American trusts, there are certain types of absolute ban on transactions with the manager and by the manager as an alternative scenario for more effective and efficient management of assets if it is envisaged during the foundation of the trust. There are certain standards for these transactions, and definitely these standards envisage the approval of these transactions by non-interested parties, and there are similar rules in our country. But apart from the fact of approval, these standards carry two other very important elements. First of all, it is the disclosure of all the information on the planned transaction to those who are approving this transaction, and the decision of these individuals is going to be legitimate only if it is taken on the basis of completely disclosed information by the manager, by the person who actually takes this transaction to the point of approval. And the concept of this illegitimacy, well, if there is a quorum, for example, if at the same time there is incomplete information, at least in the Russian Federation legislation, there is no concept like that. But in practice, if we come across a situation like that, we would like, of course, to hear how you go about that and what are the experiences. There are not that many situations like that. If we look at the Russian legislation, we can see here that there is an absence of the general look and on the fiduciary duties associated with the loyalty. In different legal acts, the approach is very different. For example, there are different types of clerks and agents who actually carry out different functions, and very often they're dealing with insignificant transactions anyway, and these can be contested. But in case there is a certain action trusted with a certain entrusted, then formally it is possible to carry out this work. With the trustees, there are no limits for commercial organizations, respectively. There is a regulation associated with the interest, but well, of course, we're talking about a limited number of these economic communities and partnerships. For non-commercial organizations, the notion of the individuals who are representing the other side of the transaction, and this is all working differently for the commercial organizations. So, in legislation on the pension funds and investment funds, when there are also managers managing somebody else's property, again, there are certain constraints and certain limitations on the managers, and a clear-cut list of the transactions that can be carried out and cannot be carried out, but not with himself, definitely, and not with some others. And there is no clear-cut definition of these suspicious counter-agents that can create additional risks to the managed property, and thus the transaction can be not exactly in favor of the owner. So this term of affiliation is used just in the legislation for commercial, for economic organizations, not for non-commercial organizations at all. As the affiliated divisions are dependent, and there's a concept of duties and responsibilities of the managers and the duty to carry out transactions that are not in his own interest. This is very important for us because this would harmonize the legislation and will actually make life easier for many, and particularly for those who believe that the foreign jurisdiction has all these details considered. When the beneficiary, when the manager potentially can act against the interests of the managed property, property, we can see another situation which is also not completely covered by Russian legislation. Namely, it is the use of those opportunities that are open for him through his status of management. The corporate opportunities of an organization open in connection with management are usually properly described for NGOs, for non-commercial organizations. For commercial organizations, there is no proper legislation. There are certain limitations, of course, described and properly set in relation to competition. And if the manager, for example, is carrying out similar actions in his own to his own benefit. But otherwise, if the manager gets certain benefits as a result of managing, this is something that is not properly regulated. So what is the rule? What is the rule of making use of the property in one's own interest? For example, there is quite a big estate, and when the assets are being placed and the banks are ready to provide different bonuses, different discounts, and they are not affiliated, they are not related with this manager, with this particular manager, but the managed property is important for them because there is a large estate, and the manager, for example, gets some sort of a personal bonus from a bank because under market conditions he transfers this property into the management of the bank. The bank is not affiliated. There are market conditions of this transaction, but then the bank thinks, why not to do something for the manager? Of course, the manager should understand that all the proceeds that he gets, he's getting just because he's entrusted by the owner, and the standard of work must be very strict, and all the property that he works with, all the proceeds should be transferred to the trust, as we might say in the Anglo-American system, or in this or that way through the Institute of Damages, should be all transferred to the estate, to increase the estate. And as I said, the third part of the duties is the duty of loyalty. And that's the duty not to compete, not to carry out similar activity. This is more typical of business management and management. Well, as a rule, in case of managing personal assets, it is quite possible to manage assets of different people and carry out similar operations and transactions. And one final thing within the context of duty of loyalty. Now, this is something we have touched upon. It's responsibility and liability. As for the transactions carried out with the violation of the defined duties and requirements, this is all quite clear. There are clear-cut rules here, and we can talk here about the bona fide counter-agent, but conceptually, well, of course, this the contesting of this transaction is no problem at all. But in case the corporate opportunities used for the personal enrichment of the manager, then, of course, there is always a question of the damages. I can envisage an argument, a counter-argument. Article 15 of the Civil Code stipulates that the proceeds received by the person who violates someone else's right, as a result of the violation of someone else's right, is lost opportunity and profit, and is to be compensated. Well, logically, it is clear. Now, the use of the lost opportunity by the manager is not the violation of the right, because the opportunity is not the right. And in the example given by me, the managed property and the fund or the trust did not have a right to get this additional earning or proceeds. So this is an economic opportunity that is not really properly executed. But we do have conceptually this notion of liability, but we do require further work on it. The Americans say we do require fine-tuning in order to make sure that this particular duty works in a correct way and to its full extent. Now, that's all I was going to talk about. It's probably too technical, but our forum is professional, and I do hope that I was able to cover some of the important issues. So professional, very professional indeed. Thank you very much. It was the most interesting presentation, and what's very important, you gave very specific examples, because our purpose was to channel our discussion properly, to step away from dichotomy, discussing whether we need trusts or we do not need them, and begin the discussion of the more fine issues. And that's why we touched upon the issue of inheritance. And I think you covered the issues that are properly regulated in the Anglo-American law. And this is actually attracts Russian business very much, because Russian business really wants to have guarantees that are provided for them by the Western jurisdictions. Any questions? Yes. Mikhail's presentation was actually a response to your question and to your comments, partially so. In one of the slides, you mentioned the public supervision of the managers. What do you mean by that? Is that a system of reporting, accounting on the transactions? Because abroad, this is the responsibility of lawyers. There is the issue of confidentiality involved. And here, just imagine the managers reporting to some sort of a public authority about the property that he is managing. I will probably try to comment on that. Now, I can just tell you that the purpose of this the discussion of these issues is not the establishment of any sort of a new profession, licensed profession, or licensing for those who want to become managers, either by the agreement on management or. Anyway, it is quite obvious that it should be a profession bound by certain standards, public standards, professional standards. It cannot exist as it exists nowadays, when any individual, any capable, legally capable person can be appointed manager, entrusted manager. There are two ways that we can follow here. First, we can create something new, a new profession of professional managers. Now, this is not the best possible option, although nowadays in different legal acts you will find different types of managers for high-rise apartment houses and so on and so forth. And in this particular context, this is not the best option, as I said. But you're right that, of course, we must have a list of the existing regulated, licensed, not licensed, but regulated professions that can deal with that. Who are these people? There is no answer at the point. At this point, we have to answer this question, answer rather. These can be lawyers, these can be players at the securities market, if we take the management of securities in the market. And so the list is open here. It's a matter for discussion, but it's quite obvious that this must be a profession. Any person from the street cannot be a manager, a trustee. Otherwise, if this is just any person, we won't be able to avoid problems. And a person who can hardly read what kind of fiduciary duties, what kind of management of securities we can talk about. I meant not so much requirements to a particular manager. I meant supervision and public supervision over the work of the managers. Does it actually mean that the managers will have to report to the public bodies? Should there be any financial accounting or any other types of reporting? Or is in other jurisdiction the manager just pays a certain contribution and that's it? And as for the property that is managed by the manager is confidential. No, the purpose is not to collect money. It's not the stamp duty we're talking about, no. We have a lot of models and effective models here, and for me the model that works at the securities market seems to be all right. Of course, there is professionalism is very much required, qualifications upgrading, and at the same time, there is a limited public control over the extreme situations. And obviously, this must be a free profession. These people should not be people in uniform wearing some sort of badges or whatever and managing. So there must be a person with a certain level of financial knowledge, legal knowledge, but it must be a free cooperation and limited public control, maybe not necessarily state control, but a manager at the securities market is controlled very strictly, and they are reporting and reporting to the Commission on Securities. And we're not acting here as lawyers abroad who are not actually reporting on the activities of their funds. Now, that's a very good issue. Of course, we can continue the discussion. Just one conceptual thing. Managers who work with an unlimited number of depositors or unlimited number of owners who potentially do not have sufficient skills to work at the investment market or stock market. These managers are, of course, under public supervision and control, and they are expected to report in all jurisdictions. But the private funds and private managers, by definition, serve the interests of one person, the person who appoints him or her to deal with the problems of a particular family. So it is difficult to compare managers of private funds and the pension fund, let's say. Well, of course, if the manager of the pension fund also manages a private fund, that's a different story, a somewhat different story. Stanislav Ivanovsky, High School of Economics. Thank you very much for your presentation. I worked a lot on trust management and different problems associated with it at the market of securities. And four very short comments, if you permit. The first one concerns confidentiality of the information that is going to be in the hands of this manager. If we license the profession, then our manager will have to report in detail to the public authorities, and then multiplied by the Committee for Financial Monitoring. That means all the information that the founder wanted to keep confidential and secret will not be secured. And then the conflict of interests, another important issue. The conflict of interests is a category that in Russian legislation is practically absent. What we have at the level of the documents of 1998 is something that is absolutely unruly. It just says if there is a conflict between the manager and the client, then this particular situation is covered. But what we are talking about is much wider. We're talking about the conflict of interest between the interests of two clients, of one manager. And in this case, the personal interest might disappear and you won't have both structures. The third question concerning the bonuses from the banks. In your example, I think that it is impossible to catch, so to say, such benefits from the manager. I think that if we take such efforts to capture the elements at the present stage, that will be too early. Such misuse or such situations really happen, but we won't be able to capture them now. And the fourth statement, which is most important, we have to assess with what we're going to appear at the court of law if we have a suspicion that the manager acted non-conscientiously. Whether we're going to prove the classical
tort or the amount of the damage and causal and consequential relation, who will bear the burden to prove that the manager acted non-conscientiously in accordance with the standards or conscientiously. And we have to develop it from the very beginning. Otherwise, we'll have a lot of regulatory acts, and when we appear at the court of law, the result will be not easily predicted, and we would like to avoid it. Thank you. Thank you very much for your comment. I will agree that the presentation was not aiming to exhaust that theme, and I just wanted to formulate the questions, including that of the conflict of interest. As to the possible conflict of interest of the manager who manages several sets of assets, that is also quite important, and have outlined the general issues concerning property management, but specific managers and specific situations, more detailed regulation would be possible through direct legislative prohibitions or procedures or determination of the standards. As for the confidentiality, I can only agree with you. And as to the responsibility of the managers, as I have already noted, if we proceed along the classical structure of the civil violation, we might have difficulties in proving the violation of the law and proving of the losses. That is quite difficult in the Russian situation. So the determination of certain rules and regulations that would simplify the procedure of levying the losses by calculating the revenues, and in the legislation or the legal practice there are rules that any difference between the market and the transaction should be recognized as a loss on the basis of the previously determined legislation. That will also make the situation easier. As to the burden of proof, that is also quite important, but traditionally it is regarded that from the viewpoint of exercising adequate management and duty of care, the irrationality of the decision should be proved by the person who states it, by the founder or beneficiary. If we mean transactions related to the conflict of interest, the proof of the conflict of interest will be the responsibility of the person who states that there is a conflict of interest. But as soon as the conflict of interest is proved, the proof that all other procedures have been fulfilled is the responsibility of the person for whom there is a conflict of interest. Probably it is not finalized in the Russian law, but it has been formulated in other legal systems. If you allow, I would now give the floor to Peter Wand, and if you have questions, they will be discussed later after the presentation, because trust is always associated with the Anglo-Saxon or common law, and there are certain risks of inventing a bicycle. And we always perceive it in the experience of our German colleagues in the sphere of private law, and it is natural that we have to make the final stop in our discussion. And so I give the floor to Peter Wand from the Debevoise and the Plimpton Company. Then we'll sum up our discussion.
Thank you, ladies and gentlemen. I'm honored to speak. Yes, it's on. Yeah, should be on. I'm honored to speak at this distinguished forum. We've talked about many subjects and technical details in the discussion today. I'm impressed by the exchange of arguments and the heat and intensity of the debate. I would now like to take one step back and focus on a couple of public policy issues associated with the debate from a German law perspective. As you can see on my copy of the slides, I've tried to take notes and hope to address a couple of the issues we've touched on in our debate today during the presentation, and hope that from a German law perspective we can contribute a bit to the debate in Russia. This is not working. Oh, here we go. Thank you. I would like to give you a brief overview of asset protection and delegated ownership in Germany. This presentation aims to be short in the remaining time, and I think it's most useful to start with a definition of asset protection. We've talked about succession planning today, we talked about trusts, but I would like to start with the definition of asset protection and delegated ownership. Then I will elaborate on what I call the basic concepts of asset protection to make clear what I'm talking about and how this actually works. Give you examples of historical and current techniques used in Germany for asset protection and delegated ownership. Give you a brief overview of main purposes of German foundations, which are probably most useful for the debate here. And finally conclude with a list of constitutional values and public policy considerations, some of which were already mentioned, some of which did not occur in today's debate. Asset protection. Well, the discussion about asset protection in Germany is a relatively recent one. Yeah? At least if you follow this definition, legal techniques to place assets of individuals or businesses beyond the reach of future creditors for the benefit of certain persons in accordance with applicable law. Yeah, note, it's placing assets beyond the reach of future, not current, future creditors for the benefit of certain persons. This goes far beyond succession planning. Yeah? This is what you see as asset protection definition in the international debate, which is triggered by the invention of asset protection trusts in the Cook Islands and then in a number of states in the United States in the 1980s, and at a certain point in time the debate also reached Germany. Succession planning, foundations, those are certainly old concepts, hundreds of years old, and we will see in a minute how they cinch with this term and this definition. Then I thought it might be useful also to define the term delegated ownership. We are talking about ownership by another person entrusted with a certain task or responsibility. Yeah, we already talked about fiduciary duties, and we will see whether you can actually fully protect your assets under German law when you give them to a third person from the reach of creditors. You might be able to do that, but it comes at a cost. There is no free lunch in Germany. And the trade-off typically is, if you cede ownership and you cede control, then you can protect yourself from the reach of your creditors. If you try to maintain control, and if you try to continue to reap the benefits, then, as a general principle, you also will be subject to your creditors. Yeah? There is a coupling of risk and responsibility and not a decoupling. That might be different in some countries and was actually the ultimate purpose of the Asset Protection Trust, for which German law has limited sympathy. This brings us to the questions, why do people seek asset protection? Well, one reason we touched upon today is succession planning, asset management, risk management. And one thing in connection with risk management you see in the debate is, liability for board members is ever increasing. We need to help these poor fellows. That's the main argument which is actually used for the establishment of asset protection trusts. Yeah, and it's coupled with an argument that D&O insurance gets more and more expensive. Yeah, whether that's a fair argument, I don't know, but we will come to the free lunch at the end of the debate. When I embarked on my research, I read a statement from a lawyer based in Singapore on asset protection, who said that asset protection should be used to protect clients from, quote unquote, sovereign greed. To my ears, sovereign greed is a reference or an invitation to tax fraud or tax evasion. Yeah, so this cannot be the purpose of any legitimate asset protection strategy. And if you look at the definition of asset protection, once again, it's in accordance with applicable law. It's not for tax evasion purposes, it's not to defraud creditors, and it's not to launder money. What are the basic concepts? The first one is the shielding of assets. Yeah, I call it the Captain Kirk strategy. Yeah, you might be familiar with the Star Trek series, and whenever there is an enemy attack, Captain Kirk turns to his crew and asks them to turn on the deflector shields. Yeah, so a shielding of assets. Here, the assets remain with the original owner, but he tries to rely on a concept to prevent creditors from having access to those assets. The second strategy is the transfer of assets, potentially with delegated ownership, but a delegated ownership, a maintenance of control, and continuing enjoyment of benefits might defeat the very purpose of the strategy, i.e., to have the assets where the creditors do not have a claim. I call the second strategy the John D. Rockefeller strategy. He is purported to have said, own nothing but control everything. Now let's turn to a couple of historical and current techniques. I've tried to group them, and the first category is gift and estate law, and we talked about estate law already today. What was very fashionable over centuries in Germany and other parts of Europe were entailed estates, fideicomisse. They have been abolished, and they have been abolished for good reason. An Anglo-American lawyer would say they were a violation of the rule against perpetuities. In Germany, there was a fierce debate in 1849, 1850 already, whether they should be abolished. They basically enabled the German nobility to pass its wealth along through generations for eternity. Creditors were unable to get their hands on such wealth. And at a later point in time, when 10% of the German forest and other important parts of the economy were parts of entailed estates, the legislators stepped in and said, no more. Yeah, they have been abolished. I think what we should take with us from the example of fideicomisse is that the rule against perpetuities is a very important one, and I think every country has this in one or another form. The next example I give you, and that still exists and used, is provisionary and reversionary testate succession with ongoing execution. Very technical stuff. The punchline here is, you do not trust your kids. They are big spenders, but you have hope that the next generation, your grandchildren, will be better. So basically what you do, you pass on your assets, but your kids will not be able to spend it. The executor will supply them with certain amounts of money, but the grandchildren will be able to enjoy the full benefit of the assets. But at the level of the grandchildren, the control of the original owner is over. Remember, no rule of the dead over the living, no perpetuity. The following examples are resident rights. When you transfer your house, you might want to make sure that you can enjoy it, but that's not the focus of today's debate. Non-attachable amounts under the German Civil Code, subject to strict limits, not the main focus of today's debate. Matrimonial property regimes are probably more interesting, but the key question here is, who's the bigger risk, your spouse or the creditor? And then you have foundations. And foundations are probably what is of interest for you and in the context of our today's debate. They can be created during the lifetime of the founder or upon the death of the founder. They are they are subject to limited public supervision, but limited public supervision. And in view of today's debate, I might add that I do believe in public supervision only to a certain extent. The question you always have to ask yourself is, what can a supervisor really do? Yeah, and I hear from clients, large German banks, well, they need to submit the slides for the management board meetings on a regular basis to BaFin. But BaFin never really asks a lot of questions. BaFin is a German SEC equivalent, the Financial Supervisory Authority. Why does BaFin not ask questions? Well, you might argue BaFin doesn't really understand what's going on. So when you put a supervisor in charge, the supervisor must be qualified really to act, and that's often not possible. The bedrock principle of foundations in Germany is there is no foundation exclusively for the founder. There is no foundation exclusively for the founder. You cannot set up a foundation, and that's different from other jurisdictions, for the sole purpose of paying you a handsome amount of money on a regular basis. What you can do, is establish a private benefit foundation, a privatnützige Stiftung. Here the founder can benefit, but he cannot be the sole beneficiary. And if it turns out that he is a sole beneficiary, the whole thing is regarded as a scam, and deconstructed. What has been very successful in Germany are tax-exempt charitable foundations. Here, the founder can provide that he and his family, or she and her family, can get up to 1/3 of the foundation's income for their personal maintenance as an allowance, up to 1/3. And now you might say, oh wow, here is a free lunch. But it's at best a light breakfast. Since the German tax authorities will not allow such a structure if the yearly allowance per person exceeds 100,000 euros. So for really wealthy persons, this is not a means, to tuck money aside, via a foundation. It's rather an incentive from the legislator for people to start giving. And creating a foundation can have lots of purposes. It can be an issue of succession planning. It can be an issue of ensuring the integrity of a business enterprise. It can be an issue of making sure that your name will be recognized in the future. In the end, a question of personal vanity. But it's not a means, to allow people to tuck away money and to decouple risk and responsibility. This slide shows you the main purposes of German foundations, and you will see that the private benefit foundations are only a small fraction. The charitable foundations, yeah, with the purposes set forth on this slide, are the vast majority, the vast majority. And what I might add in respect of the private benefit foundations, and you saw that to some extent on the previous slide, is they are fully taxable. The taxman comes by and makes sure that the income is fully taxed, and every 30 years the taxman shows up and wants to have the equivalent of inheritance tax. Yeah? Because 30 years is deemed to be the lifespan of a generation. Yeah? If the assets were owned by a private person, inheritance tax would likely kick in within a 30-year time period as well. This brings me to the last slide. Oh, sorry, I jumped one slide. Which is the slide of recognition of foreign techniques. Yeah, we talked about the Cook Islands and US state law asset protection trusts. We did not talk about Austrian and Liechtenstein private benefit foundations, and we did not talk about establishments under Liechtenstein law. German law is very hesitant to recognize trusts established abroad. They do not fit our legal system, and to some extent, German courts have recognized them. Yeah, but if they are set up as a scam, yeah, and there is no court case regarding mere asset protection trusts, but my guess is that they would be disregarded. Austrian and Liechtenstein private benefit foundations were very popular for tax evasion and money laundering. Austria actually had to change its law of private benefit foundations a couple of years ago because they were in big trouble on the international level with allegations of money laundering. Yeah? They can be legitimate, and there are good reasons for them, but the reason why they're used in many cases is because they're non-transparent. Tax information, at least in the past, and that will hopefully change in the future, was not changed with tax authorities abroad, and it was very difficult to see who actually the beneficiaries were. And the Liechtenstein establishment in Germany's public perception is associated with the fall of Mr. Zumwinkel, the CEO of Deutsche Post AG, for allegations of tax fraud. This brings us to the public policy debate. We talked about the right of ownership. The right of ownership is a right of ownership of the transferor, of the transferee, and of the creditors. So when you talk about asset protection within the sense of making sure that creditors cannot put their hands on assets which originally belonged to another person, yeah, you're also talking about the right of ownership of such creditors. You cannot take away from one person without giving another, or you cannot give another person without taking away from another. There's a question of a freedom of contract. Would you recognize trusts? And there's a question of equal treatment, which is very important for any jurisdiction when it comes to the acceptability of a concept you introduce in national legislation. Risk and opportunities, I see, and those are basically the points of the debate in Germany, and they help us to coordinate. Ultimately, everybody is dancing on a very fine line, yeah, when trying to balance the interests here. It's a decoupling of risk and responsibility while providing an incentive for economic activity. I'm finished in 2 minutes. Fine? Okay, sorry. There's a question of creditor fraud and legitimate asset management, question of tax evasion and tax planning. There's a question of rule of debt over the living versus a reliable succession planning. There's the question of limitation of marketability of assets and the integrity of economic entities. I gave you the example of fideicomisse and the 10% of German forests which were owned by the estates. Yeah, if too many assets are tucked away in such structures, that becomes a problem for the economy as a whole. Whereas when you take the example of large industrial foundations, those often were created in order to ensure the dispute among heirs did not lead to a regime where the company could not function anymore. And then you have the discussion regarding intransparent tax, money laundering havens, and investor-friendly jurisdictions. And that leads us actually to the very beginning of today's debate, the flight of capital from Russia. Yeah, my strong belief is that as a jurisdiction, the only way really is to give incentives, to give a proper legal regime and to give incentives to people to stay home. And from an incentive perspective, certainly tax is very important. Recognition and trust are others, but by no means should a discussion about a flight of capital encourage a legislator to provide for a free lunch. Thank you very much.
Мне кажется, что выступление...
It seems to me that Peter's presentation was really the fine conclusion of our discussion, and it determined the basic trends of our future work and discussion in the Russian jurisdiction. I think it was quite useful, and it just put not a point but a comma in our discussion, and the next session will be held in this hall dealing with deoffshorization, and you can stay here if you want. I would like to thank the speakers.
Да, спасибо большое. Спасибо большое спикер, спасибо большое участникам. Всего доброго. До свидания. Спасибо.